Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Wanted to go over what an unsuccessful work attempt is. This has come up today because one of my clients who has a pending claim has an opportunity to try to do what would be probably a slightly accommodated job, but full-time, and it makes nice income where, Social Security disability would not be needed to, have a sustainable existence. So, people say, I can't go back to work yet. It's not entirely true. So I just want to explain to you quickly and show you the area where you can go read it at for unsuccessful work attempt. In this particular avenue, I'm thinking about unsuccessful work attempt while a claim is pending. But this can also be an unsuccessful work attempt that happened in your past, in your more recent past, before you completely went out of work altogether or reduced. And when you're trying to think about your alleged onset date that you have to determine you're going to assert on your application. It can also happen later on when you are collecting Social Security disability and you're outside of your trial work period. They do reviews then when you're working to see if it's over SGA, and if it is it an unsuccessful work attempt. We also call it a failed work attempt, but I think the official SSA lingo is unsuccessful. So this would be, by the way, under DI 11010.145. That is you Google search that or go to ssa.gov and then add that phraseology there with the numbers. You'll come up with the very article I'm looking at. It's not an article. It's official POMS narrative from the SSA. Okay, I'm just going to read off their definition of UWA, unsuccessful work attempt. And then I want to share with you a different share that I'll attach here, specifically to the question of my claim is pending, do I have to cancel it do I have to cancel it if I try to go back to work? Can I do both? That kind of thing. And how? Because it is important how, and there are ramifications, but if you have a strategy in place to deal with what is going to come up with the SSA legitimately, it is workable, again, within the confines of UWA. Okay, so the definition they give us is a UWA is an effort to do work in employment or self-employment. By the way, that could be Ubering and other gig work, DoorDash, and any smaller enterprises like that. So that would be self-employment. When you're gigging, it's self-employment. Whether you get a 1099 or you don't get a 1099, if you're not getting a W-2 and you're earning income, you're generally self-employed. Okay. So it's an effort to do work that discontinues or reduces to the non-substantial gainful activity, SGA. We have playlists about that if you need to know more about that. SGA level after a short time, which is no more than 6 months, because of the impairment or the removal of special conditions related to the impairment that are essential to the further performance of work. Work performed during a UWA does not prevent a finding of disability. And that's the key part for when you're in a pending claim, on initial, on recon at ALJ, or if you're in a CDR, or none of the above, you happen to be a beneficiary and you're not even in any of those. So very important, of course, remember the 6-month limitation. Know also that going back to work under SGA, part-time enough to be under SGA, does not even need to have a finding of UWA to protect you. You are under SGA. So you don't have to worry about UWA or striving to determine your dates to see if you could argue a period of work was a UWA unless you're over SGA. So those are the 2 main points. I'm going to leave you to the next video, which talks more about when you're in the middle of a claim and what you're going to want to think about and consider. And I do hope for everybody who can get out there and be a little productive and bring in some income for themselves and not threaten their claim. And they have a claim because they know they cannot, they feel strongly that there's nothing they can do full time on a sustained basis for more than 6 months. There is so many things you can do to get out there to help your income, help your family, feel productive, have a social life of sorts at a job. A lot of times if we work part-time, I should add, and by the way, this UWA can be full-time, but a lot of times when we work part-time, that doesn't stress our bodies or our minds where we are already impaired. It does wonders for both. So, I mean, everyone's individual, but I don't want anyone to feel that they can't look at the possibilities. Okay. So don't let anybody tell you otherwise. I'll talk to you later. Enjoy the video. Bye, guys. Hello, we meet again. Okay, a quick note about the instances where a claimant might find that they're trying to go back to work while they have a pending claim. And that's not discouraged by the SSA because, hey, you might be able to find a job that you can do full-time on a sustained basis. So the particular instance that I'm bringing to mind is when someone is on reconsideration. That's the second stage for most states. And they decide to try this awesome job opportunity that they were just given that they think might accommodate their disabilities. I mean, they're not recovered, but sometimes we feel better than other times, and hey, why not try, right? So, you know, it does have its monkey wrench business in a claim, but in this instance, the person took a job in, say, January, and it's full-time, apparently can accommodate her needs, and it is now what did I say? January, February, March, April, May. Oops, April. I'm getting ahead of myself. So February would have been the first month, February, March, April. 3 months in, she gets denied on reconsideration, just on the, you know, their evaluation of her medical. That alone isn't concerning. That's not unusual. We fight those things all the time. But she is working full time. So when we do the appeal, obviously we have to explain that her activity has changed. She's now working full time and giving it her best attempt. So that was done. And so now she has a pending ALJ hearing. So what's the girl to do? In my opinion, what I think is a good idea and ethical and proper is if the person is attempting to go back to work despite the pending disability claim, she doesn't know yet if this is going to be a successful work attempt. We hope and pray it is, because I think she really likes the job. So we are letting it roll to see if it becomes sustained. Sustained means 6 months. She's at, say, the 3-month mark now. It is waiting for hearing now. And the fact that she's working is noted in her appeal. So if she's working at the time of her hearing, I believe even if that was less than 6 months, the judge would have no choice but to deny her. And that's so understandable. If the hearing is after the 6 months and she's worked more than 6 months, then he would be denying on that basis. Now, and that's the clincher here. If the person, you or anybody else, is working more than 6 months and there is no viable closed period, which is a whole nother issue. So keep in mind, a closed period is when you were disabled, then you were disabled for at least a year and then you recovered. You might be able to get, if you can prove that year was true disability as defined by the SSA, you can get a closed period and get paid for that, your insurance benefits for those months, minus the 5-month waiting period. But if you don't think you would have a great shot at a closed period, because you never really got the evidence where it needed to be. And that's what would have been going on now before hearing. One option is to withdraw the request for hearing based on the substance of your case. You know, I'm now able and am working at a job. It might not be a job in substantial numbers, but it won't matter because she's earning SGA. So even if the job were the same, but what she was only working less than full time and only earning less than SGA, which is $13.50 a month, she would be able to continue. But because she's working SGA, regardless of the fact that the job is not one that exists in substantial numbers in the economy, she would be able to request to withdraw the request for hearing from the ALJ. He would likely grant it. I've never seen them not grant it. I would likely give, you know, she would give a reason such as, given the status of my evidence, you know, you don't have to be specific, and my current, the SGA is a black and white issue in this case. So currently working SGA on a sustained basis. It's like you can't win a case if you're doing that. So that is one thing to consider. You don't have to drop a case that you're claiming because you started working full time. Give it a go. It could end up being what we would argue is a failed work attempt. So if she has to quit in a month because the pain is too much or the ramifications otherwise from her disabilities are too much, we would still have the case going from the get-go. There would be no interruption and she'd have her hearing and she wouldn't be working at that time. So anyway, give that some thought. If you ever decide to go to work, you can do it and still keep your case. It has risks and there's a ton of more things to discuss about it, but it's not off the table, despite what some people will say. Okay, take care. Have a good one.